time since last Friday, lawyer Oppong left us with our mouths agape at some of the very interesting snippets of information he left us with about who gets what when a marriage ends. You know, he really laid out the explanations and terms and definitions and the principles that the court considers in making those decisions. Then, of course, he shared some of his own measured opinions with us. And yes, Winston in particular was
still not settled.
It's still. And no. So today we are going to bring some clarity, finality to these matters, and we're going to do it with you. Okay, you bring us all of the questions on your mind, and lawyer Oppong will help us answer them. Right, that's what we're doing this morning. And listen, thanks to all of you who have decided that you want to be a part of the audience of the CIMG radio program of the year. Those of you who have tuned in from Kumasi to Love FM, those who are tuned in the central region on ATL FM, and all of you around the world who are joining our X Space conversation to listen live to what's going on here. Of course, those of you watching us on Facebook Live right now, you can see the quality of the tweed fabric of lawyer Oppong's jacket. You know, as he settles into his seat to handle all of your questions right here. Lawyer Oppong, it's a pleasure to have you once again.
It's always a joy to be here.
Thanks so much. Thank you so much. This time he came armed, though. You see the contemporary trends in the law of immovable property in Ghana. So massive, volume.
You know, that's his latest book.
Yes. And it's big, oh.
That's what Samson spoke about the last time.
That's right. That's true. And we're going to be learning from lawyer Oppong. We're very excited about this. Okay, let's get started. Last week, a bunch of questions came in at the end of the show. We picked about 3 or 4 of them, right?
Yes.
Really good ones. Let's start from there.
All right. So this from X at Nanaya Danko said, can properties be acquired and kept secret? B_Nav says, are baby mamas entitled to anything? At Kakra 37, why is the woman's property never talked about? Do you have claims if you helped her acquire it? And the final one from Don Cecil says, what happens when a man marries and he's owing big time and he uses persons such as Atu Essien and his wife files for divorce? Do they split the debt or that's all for the man?
Okay, so we're going to take them one by one, these 4 questions. So let's take the first one again.
Can properties be acquired and kept secret?
Thank you very much, and good to be here. Let me issue this caveat. I don't claim to be an expert in family law. I mean, the gurus at the law school, they are teaching, they've been teaching over 13 years. I'm only expressing my quasi-layman view.
There's nothing layman about you, lawyer Oppong.
Relatively, and so forgive me if I don't get the exact answers for you, but that's the whole purpose of law. There has never been one side of the coin when it comes to the law. And I just urge that we take up a position, you are able to pursue it to the end and not just give in easily when the other side is trying to bully you. Of course, if your case is bad, you admit it. But if you think it's not bad and you start the argument, push it to the end. After all, you are not the judge. Neither is your colleague. Let the judge choose. So you are the judges listening. Of course, it's good that we engage in legally founded or principles that are the foundation for debate. And that's all that we are doing. So for the first question about whether a person can conceal property acquired during marriage, I think I explained the other day that there's a principle of piercing the veil or tracing. If the other spouse is able to lead evidence to the fact that these properties were acquired jointly, as explained in the cases during marriage, then the court will the court's jurisdiction to trace these properties will be invoked, and they will be able to try. I told you in one case where the gentleman had diverted some of the properties, sold them, and invested it in his personal company, thinking that because the company is separate and independent of the owners, then he can get away with it. The court traced it and said that, well, all these properties and investments were the proceeds of the sale of the properties that you and the wife jointly acquired. So those parts of the quote and unquote alleged property of the company were taken away from the company and brought back to the matrimonial basket, as I call it, for it to be distributed equally in accordance with law. So even by concealing it, and from what the question goes, it is intentional. That in itself is an illegality. And it's an illegality of the highest order because it's a violation of the Constitution. And this whole provision we are talking about is under the human rights chapter of the Constitution. So it is the right, in fact, the human right of a spouse to lay claim to these things. Except that I said that I have my own views anyway. Now, so the court can trace both from the origin and the final destination of these properties and will bring it back into the basket. That's why I give the illustration of this footballer who said he has transferred all the properties acquired during marriage to the mother or his cash, and almost everybody was hailing him. I hold the view that he wouldn't have had his way in Ghana if there was evidence that he actually acquired this money. And the first pointer is the presumption that you should be a rich man or you should be earning so much. Because as a footballer, we all know that reasonably you gain, maybe you earn not less than, let's say, $200,000 or pounds or euros or even £1,000. You must definitely be owning something or be receiving income. And so the first presumption is then, where is the money? Oh, I've transferred it to my mother, into my mother's account. The court, because of the constitutional provision and similar laws, will trace it and at least a reasonable portion of it. And the mother, in this case, will be held to be holding it in trust for the two of you.
That is interesting. So, ordinarily, if Aaron here came to me and said, Kojo, here's 1,000 cedis. I just worked, I earned 2,000 cedis. Here's 1,000 cedis. I'll take it from him, I'll thank him, and he would never see it again. But we're saying that in the case of using the example of this footballer who gave his money to his mother, the court will say that he didn't give it. It hasn't been spent. He hasn't spent the money on his mother. The court would hold that his mother is keeping that money in trust for him.
Just because it's called overreaching the law or the court.
But that's his mother.
No, well, yes.
We all spend on all of this.
Yes, we should. And we must. But to the extent that it leads to a deprivation of the right of another person or the entitlement of another person, the law will look at what is reasonable. And if she will hold half of it for you, the other half will be transferred, will be compelled to transfer to the person who has the interest, the beneficiary, who in this case will be either your wife or your husband.
The asset here, by the way, is the guy's salary. It's not maybe a landed property or a car or something. It's his earnings.
Yes, it doesn't matter. The property here is not solely about, or quote unquote, we call landed property. I look at it generally to include income. Because then people will decide, I won't even build a house. I'll continue to rent and keep my property to myself. No.
Or dash it to my mother.
Well, I'm saying that you may, but your mother will be deemed to be holding at least a reasonable part of it in trust for the other person. And as a trustee, you can be compelled to transfer the property to the beneficiary. In this case, the other spouse.
Mama B is nodding vigorously. She likes it. Okay, next question.
Our baby mom is entitled to anything? And
Well,
this is B_now.
I will say that the Supreme Court has given some two, maybe competing decisions. There was an earlier case that says that, look, what we are talking about here is about persons in marriage and not persons in concubinage. Okay. So, in that case, the the lady was denied the claim for a reasonable share in the property that was acquired. And there's a more recent one where the court said it doesn't really matter whether you are married or not. And I agree with this second view. I've expressed it in this tiny book that is on this table.
Tiny.
Oh, for a law book, I mean, it should be twice as big as this. So this is.
Mama be thankful that it's not.
So I agree with the second view, and that's why I also, as an example of a chief, I'm sure it's not far from your hometown, Fantiland, who received this black American lady. She used to bring tourists to Ghana and renting places for them. So he met the old man, the chief. Said, well, I have this property. He planned that it should be story. He's finished with the bottom, and he and his family were lodging in it or residing in it. So the app is there, so you can continue with it. And instead of renting hotels and guest houses, that would be more beneficial. So she agreed and did that. One thing led to another, and consortium started. And then, but the old man's wife too gets to know. And I think there were some threats here and there, so he was compelled to disengage. And then they say when love ends, rancor sets in. So then the lady sued that she's entitled to a portion of the property, having invested so much to construct the story, the top floor. It was resisted until the Supreme Court took a final decision that she was entitled to the investment that she has put into the property. So another was made. Either the old man, the chief, should buy her off, or then the property will be sold, then each will take their portion. And there are a number of other cases as well. So you don't now need to show that you are in marriage but the burden is higher in this case, because here is not the fact that you are married. You may not even be living together, but you may have made sufficient or investment in the property, acquisition of the property, that you have evidence to establish. So contribution in terms of cash, probably labor, if it's sufficient, should be part of the evidence. In fact, the overriding evidence. Unlike a wife who, from the generality of the cases, may have to show that he's been cooking for you. They call it the creation of a congenial environment. Yeah, we all have it, don't we, because of our wives?
Not
Yes,
all
we
of
do.
us. Not all.
Okay. Well,
Some lose it because of
I'm not sure your mic is mute.
No, my mic is on actually, and I'm just curious because you talk about cooking and all of those things. You talk about investment.
Well, I'm giving you more part of the list.
You finish so that I ask my question.
Oh no, please go on.
So my question is: so when it happens like that, are you looking at how much the person invested, and then over the total amount, and then giving the person the exact percentage of the investment?
Well, the court have held that there's no mathematical principles. There's no application of mathematical principles when it comes to these matters. Judges are humans, like all of us. So they apply principles on case-by-case basis, generally, in most cases, unless they are bound by a decision of a court higher than it. So in general terms, they will not usually look at the 50-50, unless in addition to the performance of what we call the wifely duties, she has also made substantial contribution. Then the court may value the property. That's one that I did. The court said that, look, beyond everything, the lady was able to provide windows and doors and other building materials. So he made the order that the property be sold and 50% of the proceeds given to the lady, or the gentleman who is my client, or was my client at the time, he still is anyway, should buy her off and pay the value. Of course, then you have to ask for maybe installment payment, and that is also done. So it will depend on the nature of the claim. If it's just by the creation of the so-called quote-unquote congenial environment, which has enabled the other spouse to be able to go out there, work hard, earn income, and acquire the properties, then it may not be reasonable to ask for or be granted equal share in terms of 50-50.
Right.
Well, I mean, just a quick one, a follow-up. So if you're talking about, I bought doors, I bought windows, that's a contribution. Fantastic. But should we not also, because you're talking about contribution, and contribution can only be measured, should we not then put values to the contribution and give you your contribution, since you are talking about contribution?
Well, so that's what I'm saying, that it is on case by case basis. But if, for example, it is because, for example, I had to give up my job to be able to stay at home and take care of the children, then all that I lost, and this also happened in one of the cases, well, the one I was talking to you about, a young woman who had to give her her job, marry this pensioner, and the court had to even take that into an account, that because of she losing the job, the income, if he was in Ghana, the Senate contributions, other insurance, other maybe provident fund that she would have gotten from this employment, she has lost it. So the court will go beyond these mundane matters and go into some complex examination of the whole thing and come to a conclusion. So if, for example, because she stayed at home, was able to manage the home for you, as, let's say, a clerk, you've now risen to become an officer and you are earning more and all that, and it can be argued successfully that the contribution of the person, though not working, would have contributed to it. There was one that it was a footballer, and the lady was quite lettered. So she had to write letters for him. And she had to follow him wherever he went throughout the world. When I mention the name, you know he's very
more
famous.
Like an
footballer.
assistant.
Yeah. And at the end of the day, when they were to divorce, the court had to take all that into consideration. Even the fact that you should have taken an interpreter, but because she speaks English and you don't, she's able to communicate with these proprietors, and you were able to get good teams to play, which has earned you so much wealth. The court will not discount the contribution of such a person, even though on the face of it, it cannot be physically examined.
Yeah.
But the value is inherent.
You made a point before we go to the next question. I think you've probably given us another, prenup level bombshell. Because what you've explained to us in answer to the second question is that you don't have to be married to be entitled to a share of, your spouse's.
But he's not even your spouse.
Yes, exactly of the man's wealth. If you have a child with him, you don't have to be married to him. So for men who are thinking that a way out of having to share property with a woman is to have children with her without marrying her, that is not a way out.
Well, they may have to think again about it. But the problem is it the case that now marriage, as I said the other, has become a joint venture to the extent that we even care more about property to acquire and not the children that if you are blessed with, not the quote unquote the love and so on. But just before I forget, let me just throw this in because you brought in the prenuptial agreement. What you have to take into account, one, on these agreements, whether prenuptial or during marriage, is the nature of the agreement, how it is made, where it is made, and when it is made. Because in one case, and again, I will not mention their names, but every keen lawyer or student of law at this level knows. The gentleman said that, yes, I signed the agreement giving out this property to my wife under duress. in the night, in the midnight. You want me to read it to you?
I would very much like to hear the words by which this man explained his midnight duress.
So the respondent, who did not deny the authorship of Exhibit E, explained that he was compelled to execute the said document at midnight in their bedroom from harassment of the petitioner. That's the woman.
Wow.
In order to maintain peace in their relationship, and that he did not intend to have any legal binding force.
Amazing.
That is what the boys call talk, but it's preceded by an F word.
Okay. We are all on board.
Too much in the morning.
This is the super morning
such
show.
agreements, such agreements may suffer a declaration of invalidity. So you have to be careful. You don't want me to highlight how it is made. It should usually be in writing, but not in the bedroom. Obviously not midnight, and obviously not as a result of undue influence or deprivation of entitlement of consortium. If you don't sign it, then me too, I'll wear jeans till the month is dead.
Wow.
Those things are called vitiating factors, and they will render the contract generally invalid. So know when and where you engage in these agreements as spouses or maybe persons yet to marry. We can expand it later. But
We
it's
will
actually
expand
a case
later.
that the Supreme Court itself had to take a second look at when the man argued. And in fact, that agreement was discounted.
Right. Lawyer Oppong is educating us. And we're about to take your questions in just a short while. When we come back from these messages, we'll open the phone lines for you to ask what's on your heart. All right, we have our first caller. This is Mieza from Accra. Mieza, good morning.
Good morning.
So, what's your question?
Yes, good morning to Director.
Morning.
Director, I would want to tease your mind on the presumption of advancement in respect to Article 22, which talks about spousal property. And the presumption is saying if you bought something in the name of your wife, it is presumed that you intended to gift it to your wife. And looking at our constitutional provision on what do you have to say with that principle, with the current constitutional provision? Thank you.
Right.
Thank you for that one, Mieza. Great question. We'll take a few of the calls and then we'll get to the answers together. Again, 30 seconds, please. Nana Kwesi is in East Legon. Hi, Nana Kwesi. Good morning.
Hi, good morning.
Thanks for calling us.
You're welcome. So I have a question about baby daddies. If baby mamas are entitled to, is it the child or the woman who is entitled to this? And what about baby daddies too, who are taking care of their children instead of the woman, like we want it to be? What about that one too?
Okay.
Are they entitled? Yeah, baby daddies who are doing what we say the woman should do, even though others subscribe to it.
Wonderful. Thank you, Nana Kwesi. Let's go to Kumasi. Ken is listening to Love FM and he's on the phone right now. Ken, good morning.
Yeah, good morning, Kodie.
My brother, what's your question?
Yeah, Kodie, I think I heard a lawyer saying if you have a child with a lady and the law compelled some of your properties go to the lady. I want to know whether specifically to the lady or to the child.
Okay, so it's the same as Nana Kwesi's question. Is it the lady who gets it or is it the child? Great question, Ken. Thanks for calling us. It's our very own Ajiman Joseph from Tema. Hi.
Yeah, I'm very well.
Small. We're managing. How are you?
Yeah, I'm very good, by the grace of God.
Your question?
Please forgive me if my issue was touched on last week, because last week I couldn't start from the beginning. Listen. My question is, assuming I'm married to Madam MFR and she says I'm calling for divorce, but the issue that she's standing on for divorce doesn't hold water, and I shouldn't be accused of anything, but she still wants to go for divorce. In this case, do I still have to compensate her with whatever properties they are having, or she rather should compensate me?
Right. So you are asking about fault in divorce, whether that affects the distribution of wealth. Great question, Ajiman. Thank you. We've got a call from Medina. Hi, Ishmael. Good morning.
Good morning, Kodie. How are you?
Not bad, my brother. What's your question?
So my question is, in all this, what happens in a polygamous marriage when there's a breakup?
Mm-hmm.
Thank
Okay.
you. That's my question.
Great question. Thank you, Ishmael. I think we have 5 questions to go with now. Okay. So let's get answers to these, and then we'll come back for more. Mieza, he asks about
Presumption of advancement.
The presumption of advancement.
Yes, that's a good question. And I have, in all humility, taken my time to explain it in this book. In fact, the case I referred part to you concerning signing documents in midnight actually referred to the book and the position I've held in it. So the Supreme Court agreed with my position that presumption of advancement is unconstitutional, in the sense that the Constitution has clearly stipulated that when property is jointly acquired, then in the view of the framers of the Constitution, there's a presumption of advancement. There's the presumption that it is jointly acquired.
Right.
And so it, for me, then replaces the presumption of advancement, because you cannot then say that, okay, if I bought it for you and now you are the owner, then it means that it still belongs to the two of you, because you acquired the property during the subsistence of the marriage. So if you, as I said, because of the other thing I expressed, I don't want to mention the name of the case, but if you get a copy of the book and perhaps maybe call me on the other side, I can give you the title of that case. It's a 2020 case, I think. Yes, 2020 case, in which the Supreme Court, per our JSC, an interesting personality, well learned and so on, if I may say so, said that yes, that used to be the position under common law, and that under the Constitution, as I had posited in the book, the principle of presumption in favor of a woman is no more constitutional. So he said we agree in principle that the pronouncement above used to be the common law position on the issue under consideration. That is, once property is acquired by a husband in the name of a wife, it is presumed the husband intended the property to belong solely to his wife. However, as Oppong rightly commented in his recent book, Contemporary Trends in the Law of Immovable Property, the applicability of this common law principle or concept of advancement to married couples in modern day Ghana is now moribund. I mean, he's quoting me. In view of the radical evolution of the law on property rights of spouses, as the author rightly stated, under the current state of the law, once property is acquired by a couple during subsistence of the marriage, there is a presumption that the property was jointly acquired and therefore jointly owned, irrespective of the spouse in whose name it was acquired. So I think that answers the question. I hold the view that they may have problem under the Constitution, and as the Supreme Court has also affirmed, it may be unconstitutional.
Okay. Nana Kwesi asked 2 questions actually. First of all, he said that whatever a baby mama is entitled to, by law, is it going to the baby mama or the baby?
Well, so one, whether or not the baby mama made any contribution at all, it wouldn't affect the child, because all the principles agree, and the Children's Act, the foundation of the Children's Act, I should say, is that the interest of the child is superior to all other considerations. So whether or not a child is born out or in wedlock or out of wedlock, as you put it, we don't have the concept of illegitimate children. Once is your child, it doesn't matter whether you're married or not. But the baby mama may have interest if she does, for example, what this American woman did by making actual contribution. In that case, then whether she is married or not, she will still have an interest in the property that is acquired. But as I said, her burden will be higher, more onerous to discharge than that of a person who is actually married.
Right.
Because, and that will take it out of Article 22, which is only about spouses, people who can show evidence of marriage. But if there is no evidence of marriage, it doesn't mean that if you have made contribution to acquisition of property, the man, just because he has not married you, is entitled to everything.
Right.
So your claim is not in relation to whether or not you are married or you have a child, but in relation to the fact there has been joint ventureship of a nature, and you have made contribution which should not go waste.
That also answers Ken's question from Kumasi. Now, Nana Kwesi had a part 2 to his question. He said, what about baby daddies? Does the law work the other way around as well?
Yes, it's the same thing. It's vice versa, in my view. If you are, there's a baby daddy, not just because he's a baby daddy, but it's because he may have made some actual contribution, quantifiable, to the acquisition of the property which the woman says she owns.
Right.
That baby daddy may be able to successfully lay a claim to that property in accordance with the contribution that is quantifiable in terms of the acquisition of the property.
And that property could be the woman's salary. As with the
No, in this term, it may be more difficult to use that because you are not actually married. But where, for example, you bought land and then the two of you started building. But I hold the view that, as a man, why should you claim property you have bought for a woman when you are in love? I don't still see whether baby mama or baby daddy or not. Why should you?
But doesn't being in love, serve as a vitiating factor, since it might affect your, state of mind?
No, meaning to love and be wise is not given to men.
Hallelujah.
Well, you should have known that that principle is still applicable and find other means of gaining further wisdom than that.
Lawyer Oppong is answering our questions. Ajuman Joseph had a very interesting one. He asked about fault. Whether, if the person seeking the divorce cannot directly identify a particular fault for which reason the divorce is being sought, can the person still lay claim to your property?
Yes, it's a good point. Last week we highlighted it. Unfortunately, he says he didn't listen. The only caveat to my position is that you cannot be the cause of the dissolution of the marriage and still take advantage of it. And some people don't agree. In the UK right now, you don't need to show that there's adultery or unreasonable behavior. He doesn't cook. She doesn't cook for me. She wears jeans when sleeping. She doesn't care about my parents. Those kinds of unreasonable behavior. In the UK, you don't need to show a fault. I'm just tired. I don't want to marry again. Let's go to court. Let's dissolve the marriage. Let's share our property if there is any. Look at who should be given custody of the children. Reasonable access. They are finished. But in our laws, you still have to convince the judge that the marriage has broken down beyond reconciliation as a result of some facts: adultery, unreasonable behavior, not living a husband and wife for a number of years, and so on and so forth. If you are not able to establish it, the judge can sack you from the court and say, you people go back and marry.
And stay married.
Yes.
Wow.
So I have argued that in order not to then turn marriage into some based on the law to be a tool of fraud, that you think we have sufficient property now. Even me cry, what am I in this marriage for? Then you intentionally commit adultery. Make sure your wife sees it. Sometimes even bring her home. Have you not seen that I'm committing adultery? Some even go to the extent of going to court to say that he has broken one of the rules. And therefore, the marriage is ripe for dissolution. Just take the property and go away.
Wow.
You understand? So I hold the view that whoever generates the fault, if it's substantial, should only be entitled to some aspect of it, because without the marriage being dissolved, you would have continued to enjoy the property equally. So I'm concerned about the 40. So from what the answer to what he's saying is that if I'm a judge, I will look at the 4 system, but I'm saying that some of the courts, including our friend the footballer in whose marriage there were some 3 children and so on. Yes, that argument came up. That is obvious as evidence that there's adultery. So why should the person still be entitled to property? And the court said no. She had already earned the entitlement because of the contribution she made, which led you to even acquiring substantial properties. What she had done subsequently cannot, as it were, clean off all that contribution whilst you continue to have the benefit for it. So it cannot obliterate the entitlement. But perhaps from then on, that is where she may not be entitled to. So whatever act of immorality that she or illegality that she may have engaged in cannot be said to have poisoned the fruit of entitlement.
That's interesting.
Yeah.
That's interesting. So, and in this case, of course, it was the footballer who took the case to court, was it not? Right. So, but what your position says is that whomever is seeking to dissolve the marriage should not benefit if they are at fault.
Not so much as that, but whoever causes the ground for dissolution. There's something we call constructive desertion.
Right.
So I've left the house. So ordinarily I've deserted the home. But your actions, conduct, misconduct have pushed me out. So that even though you will go to court and say that well, I'm tired, I've left the home, because then you say that the other spouse's actions push me out. In that case, you may not have caused the dissolution, the ground for the dissolution to occur.
Right.
So it's not so much who goes to court first, but it's so much about who caused the ground to occur in the first place that has led to the marriage being broken down beyond reconciliation.
Interesting. All right. Last one was our polygamous marriage.
Yes, that's a very interesting one. I've again argued that it appears nearly all the cases, a substantial part of them, have been about the ordinance marriage. One man, one wife. One wife, one man. What about polygamous marriage? How are you going to measure the quantum that goes to each of the wives? Now, is it because, will you say that one has lived with the man? You don't know how we have suffered. When we started, it was single room. We had to partition it so our children, and if you happen to have an abeku in the room, you know what that will happen. We suffered. Now, the man has become a lawyer. We have built our property. Then you come in to marry. Fine. But then the other person, I'm a pharmacist. I earn so much a year. I have used my knowledge to and my license to even establish a pharmaceutical company or outlet. And your husband has also made contribution to it. It is the income from this that has led to this astronomical improvement in the income of this our husband. So are you looking at the number of years when there was so much suffering anyway, or the later part, within a short time, the man has been, or maybe he's a lawyer, then you are in the same firm, go to court, make a lot of money. How are you going to measure what is equal, commensurate with the contribution of each of them? So these keep coming. I even add our mothers. I mean, my mother had to sometimes sell her own precious clothes and jewels so she can pay my fees. But I've married. And then, as it is the case, within maybe 8 years, the marriage is dissolved. And everything I have should be divided into 2, or as the case may be, what about my mother, who also made substantial sacrifices to even make sure I go through my Pope John Secondary School, and apparently the best school anyway.
It is.
And to go to become who I am now, should we discount that also? That's why I hold the view that in thinking about your wife, your children, and all these complex arguments, don't ever forget those who made the contribute, those who gave you the gari, the shito. Your sisters virtually killed themselves for you, and all you think about is your wife and children. That is also a problem.
Lawyer Oppong is answering our questions. I think we have time for maybe 2 more calls. Okay, let's see if we can take 2 more questions from you, and then our time is almost up. Amazing how fast it flies. So call us 0302 216 or 055 1111 997. If you have questions for Lawyer Oppong, give us a call. Should we deal with the one about
what happens when a man marries and he's owing big time and his wife files for divorce?
Yeah.
Do they split the debts?
Well, that's
actually, before you answer, I think our call has come through. We don't want to keep them waiting. So Nanaya is in Adenta. Hi, Nanaya. Good morning.
Hello, good morning. I have 2 questions.
Okay.
One, let's say you met somebody, the man was already married but divorced or separated, and it's in court, and it's about 8 years now. Can you go ahead and marry the man? Because it's not so done the divorce. Okay. Number 2, during these 8 years, you have also done some things with him, helped him put up a building. Can you lay claim of that?
Okay.
Should you want to dissolve this 8 years relationship?
Okay. So your first question is, can you marry someone who is going through a divorce in court and has been doing so for 8 years? And 2, if you decide to end that relationship at some point, are you entitled to anything? Thank you, Nanaya. We've got another lady on the line. Janet is in Kaswa. Hi, Janet.
Yes, please. I stood on the phone for so long. We were talking and I was on it. So please, I only want to ask. By the way, ask the lawyer is I'm suing for that. And by the way, my problem is, for instance, when I was a child, like my daddy passed when I was just a child, and our gratuity was supposed to be given to us. And then my mother was the one taking the gratuity. Instead of it going to me, I went to a torture. So if something like this, can I sue my mother for that? Because we did not spend the gratuity, most of them on us. We used it for other things. And we went through a lot. She used it for other things. And we went through a lot. So as I've grown now, knowing that she deprived me of all those gratuity, can I sue her?
Okay, Janet, thank you. Thanks very much for your call. All right, let's get answers to these 2. Nanaya had her part 1 and part 2. First of all, can you marry someone who is going through a divorce for 8 years in court?
Oh, well, I mean, if it's an ordinance marriage, until the court of law, competent jurisdiction finally pronounces that the marriage is broken down beyond reconciliation and actually dissolves it. Usually, even the marriage certificate will be presented in court and virtually cancelled. Until then, any marriage will be null and void. It will be deemed not to have happened. If it's matrimonial, if it's customary law marriage or a Mohammedan marriage, the rules are very clear. It can always be added to. For customary law, all you need to do is to compensate your existing wife. And then you can add up to it, even though she doesn't have the right to even refuse to consent. The consent cannot be unreasonably withheld. You will still add anyway, but then you need to respect her, because it's like what form no?
Right.
You have hurt her in a way, and you need to compensate her before you marry the second woman. So that's the answer. Until the marriage, which is under the ordinance, is dissolved by a court of competent jurisdiction, any marriage is an illegality, is null and void.
Okay, then Janet wants to know, she's discovered that her mother may have been withholding money from her father,
gratuity,
when she was a child, can she sue her mother?
Well, I mean, you have to establish your entitlement. Because of that, were you deprived of the right to be educated? Because there are things we call necessaries of life, which is every parent's responsibility to provide. You also have to look at what we call limitation period. How long is it up to now that you now want to sue? And I think these are the matters that even settlement, arbitration, and so on. I think she should engage family members. And if there's anything left or there's some investment, then I think the income may be a good portion for her. And she shouldn't, in my view, sue. She may have to talk to some counselors. If she even comes to the Ghana School of Law, I told you we are going to have a program. We have some lawyers and judges well versed in these matters. We always want to encourage family cohesion and not division in a family. And to see your mother can have far-reaching consequences beyond our lifetime.
Yeah. Lawyer Oppong, our time is up, but before you go, we have to get an answer to that question about liabilities.
Right. So, as far as I'm concerned, I mean, the last time we spoke about where, let's say, one of the spouses borrows from a bank and puts up a property, the law is that until the loan is fully paid off, you may not have an interest in it. There are other arguments against it anyway, but that's the decision. But customary law says even the death of the woman should all be for the man. How much more that of the man? The woman should not have any liability jointly when the liability is solely that of the man. But if the liability is as a result of a joint ventureship, a business or so, then the fact that you are married doesn't take away your liability from being discharged. So you may have to discharge your liability. There's also the position that some courts are even slow in allowing a bank to get an order of the court to sell matrimonial property. If the debt is the debt of the man alone, some of the courts say no. If it's his debt alone, he should find a way to pay it. We will not allow you to sell the matrimonial property.
But what is
it happened to
alone?
Two famous senior lawyers.
What is debt of the man alone? Isn't everything jointly owned? So if we're married, I go and borrow money, we go on holiday together, we spend the money. Now I'm the one paying every month.
So when you borrow, there's always a purpose for the money, for the borrowing. Apply the loan for the purpose for which you acquired it, and not divert it to go on holidays with it.
Maybe that's why I borrowed it.
But if that is the case, then you take your victim as you find him or her. Now, so like, before we close, I'll still, I think last time I said I'll get a date for our program. 24th November is the date. We're doing what we call legal clinic. As many times as you may find, that's announced to the general public. They should bring their legal problems to us. And we are not Jesus, but we will find some guidelines and where possible solution to ensure that at least we live in a peaceful environment. Our students will learn. Even we, the lecturers and the lawyers, the judges will learn. We're also giving it out to society. Only cases that we can apply law to resolve. There are some that if you need counseling, you may also fall on other experts, psychologists and so on, to also help. So that at the end of the day, the law school is not only a place to come and learn and go, we also give it out to society. But just to conclude that for the children of the marriage, I say that it is just too disheartening to see people, especially men, working hard and struggling just to build for their children. When they say, oh, but the Bible says you have to leave inheritance for your children, there's no inheritance, in my view, more than education or better than education. Train your children, give them the best education. If they want business, put them into a trade. And reserve a bit of it for yourself also. Kill ourselves too much. When they grow up, that your property at Ashalaja or at even at Denta will not be attractive to them. You will come to cantonments and get some townhouse or even travel. And that property eventually becomes the tool of division in fighting, in tennis field after your death. Think about it. It's good to leave a legacy and inheritance, But education 1, education 2, education 3, and lastly, good life and conduct.
Lawyer Paul, thank you.